So you can't see this, but hopefully you can hear it. Behind every Boise State Public Radio podcast is a team working hard to bring you stories that matter. So if you value podcasts like this one, please support them. Hit donate at boisestatepublicradio.org. Thanks.
More Idaho Matters now from the studios of Boise State Public Radio News. I'm Gemma Gaudet. It's a story that has generated enormous confusion and a lot of heated debate. The Supreme Court's recent ruling involving President Trump's executive order on birthright citizenship didn't actually settle the big constitutional question of who is entitled to U.S. citizenship at birth. Instead, the court addressed something more technical, potentially just as consequential, and it's the power of federal judges to block a policy nationwide while legal challenges move forward. So to help us sort through what the court did, what it didn't do, and then what happens next, we're joined once again by McKay Cunningham, graduate professor and director of the Master of Applied Public Policy program at the College of Idaho. McKay, nice to have you back on the show.
Hi, Gemma. Nice to be here.
Okay, so McKay, for listeners who haven't followed every single twist and turn in this case, what is the single most important thing the Supreme Court decided in this decision?
This decision, the Supreme Court decided that a presidential executive order that attempted to materially change birthright citizenship, which is enshrined in the 14th Amendment of the U.S. Constitution, that executive order that attempted to change a constitutional provision was unconstitutional. The president does not have the power unilaterally to materially change a clear provision of the U.S. Constitution.
Okay, so the headlines often said this was a birthright citizenship case. Now, the court, in my understanding, didn't actually rule on whether President Trump can end birthright citizenship by executive order. So can you explain that distinction?
Yeah, maybe we're at a little bit of a discourse in the sense that, the Trump versus Barbara decision is just got handed down very recently that has achieved a lot of national attention. Suggested that the birthright citizenship provision enshrined in the 14th Amendment means what it says. And that is that any person born in the United States, regardless of whether or not their parents were here in an undocumented fashion, regardless of whether or not their parents were here on a temporary visa, that person who was born on the soil of the United States because of this constitutional provision is a citizen of the United States. And that cannot be changed by an executive order. And it needs to be changed, if at all, through the proper way to change the Constitution, and that is through 2/3 of the houses of both Congress and then 3/4 of the states to ratify.
So is that one of the takeaways then, is that, executive orders only have so much power in regards to the Constitution? Because, as you said, this is part of the 14th Amendment of the Constitution, and no president can just through executive order change something that's in the Constitution.
That's exactly right. And one of the things that I think is most interesting about this case is that it should have been 9-0, meaning 9 justices invalidating this executive order rather than just 6. The case was 6-3, but technically, Gemma, I think it was really 5-4. So the upside is that the rule of law vis-a-vis the Constitution was upheld. The downside is that 4 justices decided not to rule in favor of the Constitution in this particular case. If I could say it differently, it would be this. If I put this question on an exam for my constitutional law students and they got it wrong, it would be hard not to fail them because this is one of the very, 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 very rare instances in which you have a clear provision of the Constitution and you have an attempt to change that provision of the Constitution in a way that is that we have known for decades, for centuries, that you do not do it this way. And so that's really one of the real takeaways in my mind is that 4 justices of the Supreme Court would have held the president's executive order to be valid in this case.
In a dissenting opinion, Justice Samuel Alito called the ruling, and I'm quoting his writing, quote, one of the most important decisions in the history of the court. He also called it a serious mistake. He said, a quote again, careful analysis of the text of the 14th Amendment and the process that led to its adoption shows that it does not degrade the concept of United States citizenship in this way. Instead, the 14th Amendment confers citizenship on only those children who at birth owe allegiance solely to this country. Yet, McKay, in the majority opinion, Justice Roberts emphasized that children born of parents unlawfully or temporarily present in the United States satisfy both elements of the Citizenship Clause. He says under the Constitution, they are citizens at birth. So those are two incredibly different readings of the 14th Amendment. So as you said, we had 4 justices basically dissenting in this, but what do those two opinions, how does that inform you of what happened in this case?
I think it's critical to confirm that there are very good arguments to change how we have been doing birthright citizenship since 1868. There are very good arguments, and some of them were made by Justice Alito, and you've identified some of them. Maybe we should make sure that before we give citizenship away to anyone, that they have some more sense of allegiance to the United States than if they are just happen to be traveling through the United States on a tourist visa and have a baby then. Maybe we should. And so I that's not part of what I'm here to talk about. I think those debates should be had. But with regard to the rule of law and with regard to how we have almost always interpreted constitutional provisions, that's not how you do it. You don't just change the Constitution because you feel it could be done better. I mean, so Justice Roberts in the majority opinion approaches this question in the way that it really should be, in the way that you would actually expect conservative justices to also approach this problem. First and foremost, you look at the text, you look at the language. What does the actual words of the Constitution provide? It says a person born in the United States subject to its jurisdiction is a citizen. Okay. Then Justice Roberts goes to the next step. After you look at the language, what did the founders intend? Like, what did they want that language to mean way back in 1868 when that language was drafted? And Roberts walks through the congressional debates that occurred in the 1860s to determine what those words mean, including subject to the jurisdiction thereof, which Roberts says the founders clearly meant as a narrow exception for foreign ministers, for foreign consuls and diplomats who were in the United States, yes, but were not really subject to our jurisdiction and had some qualified immunity. And then Roberts does the next thing. He says, well, let's look at history. What was the legal landscape way back in the 1800s? Let's see how that informs what the founders thought when they created this provision in the 14th Amendment. And the history is also very clear that the United States inherited this idea of universal birthright citizenship from England well before we were even a country, in that we adopted that idea of birthright citizenship after the Revolution, before even it was codified in the 14th Amendment. So it's this kind of legal reasoning that we typically expect from all of our justices. And that's why Justice Alito, when you were referring to his dissenting opinion, yes, he identifies perhaps some good reasons to change birthright citizenship, but none of them are legally reasonable, even in saying all of a sudden, right now, all of a sudden, we're going to say that subject to the jurisdiction thereof means allegiance. That's never been a part of that phrase in the Constitution, and the Supreme Court here to now has never said that allegiance is part of that phrase, subject to the jurisdiction thereof.
And McKay, I mean, bottom line, because this, the justices have now, made this ruling, what does that tell us about certain guardrails? And what I mean by that is that presidents have certain powers, right? But when it comes to changing the Constitution, on a whim because they might not like something in the Constitution. And I'm not only talking about the current president, because we're going to have another president someday. Do we want those powers given to any president? So, what should that takeaway be on this ruling outside of just birthright citizenship, more about the Constitution, if that makes sense?
Yeah, I mean, one of the arguments that the current president and his supporters are making is that birthright citizenship, as we have understood it for decades and decades and decades, has a couple of big problems. One of them is that it is a perverse incentive for illegal immigration, that people want now to come to the United States, even though they're undocumented, and have a child, because then that child, by virtue of birthright citizenship, is a citizen. And then arguably the parents could achieve citizenship's status more easily by virtue of the fact that their child is now a citizen. Another argument that the president and supporters are making with regard to why we need to change birthright citizenship is called birth tourism. And this idea that people come to the United States for the sole reason of having a baby and then go back to their home country so that their baby can have dual citizenship, so that their baby can be a U.S. citizen. So to answer your question, Jim, I think one of the things that the president can do, that Congress can do, short of changing the provision in the Constitution that allows for birthright citizenship, is address these problems in different ways, is to create laws or to promulgate laws that disallow immigration into the United States, or better enforce immigration into the United States, as well as make it illegal for people to come to the United States for the sole purpose of having a baby. So there's ways to address the problems that they identified with regard to birthright citizenship without actually reframing a constitutional norm. Short of that, I think they have to do it the right way, and that is through constitutional amendment.
The U.S. Supreme Court has handed down another landmark decision in one of the most closely watched culture war cases of the year. In a ruling that involved cases from Idaho and West Virginia, the court said states may restrict girls' and women's school sports teams to athletes who are biological females. Now, the decision touches on questions of fairness and competition, equal rights protection under the Constitution, Title IX, and the rights of transgender students. Now, supporters say the ruling protects women's sports, while opponents argue it excludes a vulnerable group of students from full participation in school life. So McKay Cunningham, graduate professor and director of the Master of Applied Public Policy program at the College of Idaho, is still with us to break down this latest decision. So McKay, for folks who maybe only saw a headline, what exactly did the Supreme Court decide in this case?
The Supreme Court decided in this case that Idaho's statute that you just identified, which is called the Fairness in Women's Sports Act, that Idaho's statute, which disallows transgender girls and women from participating in athletic activities within the state of Idaho in public settings, that statute is in fact constitutional, or said differently, it is not unconstitutional, and that it does not violate Title IX, that federal statute that prohibits sex discrimination within schools that receive federal funding. So that's the short answer with regard to what the court ruled in this particular case.
Okay, so can you explain the difference between the Constitution and Title IX? Because it seems like maybe those are kind of two separate legal questions the court was dealing with.
Yes, for sure. Title IX is statutory. Title IX is a federal statute. It's a federal statute that prohibits sex discrimination in any school within the United States that receives federal funding. The court's opinion with regard to Title IX was actually unanimous, Gemma. All nine justices ruled that states can determine gender by virtue of biological identification for purposes of Title IX. The other big, and I think in my mind, the bigger cause of action was that constitutional law one. And that's the argument that plaintiffs made, that this statute, that Idaho's statute, violates the U.S. Constitution because it turns on gender. And we can get into that if you like, but that, I think that is probably the bigger of the two issues that the court decided in this case.
Okay, so talk a little bit more about that. I mean, what was their legal reasoning behind that conclusion?
Yeah, the plaintiffs argued that when you look at Idaho's statute, it's clear on its face, it turns on gender. It creates a benefit to some people, a detriment to others based on gender. And as a result, this is the argument from the plaintiffs, as a result, a
Hmm.
higher level of scrutiny ought to be applied. So we can think of a lot of different cases over our history as Americans where there have been laws that turn on gender and detriment females. And as a result, because of those history, the court has said under the Constitution, we're going to give them a little more protection. And this is what the plaintiffs were arguing. In this case, Idaho specifically carved out a detriment to transgender girls and women, specifically detrimenting them on purpose. And they don't have really a valid interest other than animus towards this discrete and unpopular group. That was one of the principal arguments made by the plaintiffs. And by the way, one district court here in Idaho happened to agree with.
So the dissent, McKay, didn't just disagree. I mean, they strongly disagreed. What were the central concerns raised by the three dissenting justices?
Three dissenting justices in in the Supreme Court. Yeah, the dissenting justices said that very thing. In other words, what the majority did was say, nope, this law is constitutional. End of story. Period. We're done. The three dissenters said, no, it looks like Idaho is carving out a detriment for this unpopular group, and at minimum, they should have their day in court. They should be able to present the merits at the district court rather than having this case completely truncated here at the Supreme Court by ruling that Idaho statute is constitutional as it's written.
Mm-hmm. So, McKay, does this ruling mean that every state must adopt similar restriction, or does it simply allow states to now choose how they approach this?
It's a great question, and the answer is the latter. A lot of people have identified this court's opinion as being kind of narrow in the sense that the court is really saying, look, this is a states' rights issue. States get to decide. We don't want 5 justices out of 9. We don't want a majority of Supreme Court justices who are not elected, who are not accountable to the people to make this decision. States get to make this decision. And that also means that the 23 states and the District of Columbia and Washington, that the 23 states that do have proactive laws protecting transgender people from discrimination, those states and those statutes remain valid. In other words, this opinion that allows Idaho's law does not affect other states' laws who proactively protect transgender people.
So I have a little bit less than 2 minutes with you. So looking ahead, are there other legal questions that involve transgender rights that are still unresolved? I mean, and could the Supreme Court eventually take up other cases?
Oh, for sure. And one that comes immediately to mind is the Idaho public restroom ban, which, as you may recall, there was an injunction issued by Judge Brailsford, I think around the 16th of June, so very recently. And that case obviously deals with whether or not this group of people, transgender people, can be singled out for a crime. And that's a big difference between these two cases. Can transgender people be singled out for a crime if they use a public restroom that is not synonymous with the gender that they were assigned at birth? And that case, I think, is one to be watching very closely. I do not think, at least on all fours, that the opinion that we just got from the U.S. Supreme Court, do not believe that opinion determines the outcome of the bathroom ban case that is currently being litigated.
All right. Well, as always, McKay, we so appreciate you taking time to walk us through all of the legalities of these cases. So appreciate your time today. We've been talking with McKay Cunningham. He is a graduate professor and director of the Master of Applied Public Policy program at the College of Idaho. You've been listening to the Idaho Matters podcast from Boise State Public Radio. To stay in touch, you can find quick Idaho daily news every morning when you subscribe to the Connector podcast. And text this podcast to a friend. It's how podcasts grow.
Each story you hear on Planet Money starts with a question. What happens if we refund tariffs? Why are groceries so expensive? At NPR, we stand for your right to be curious because the forces shaping our world can be hard to see. Follow NPR's Planet Money wherever you get your podcasts and start seeing how the economy really works.